Welcome to the EXCELcast. My name is Mark Clegg. I'm the Director of Entrepreneurship and Career Services here at the University of Michigan School of Music, Theater, and Dance. And I'm here with James Kendrick, who is going to be a terrible person to introduce because he does just about everything there is to do in the American music publishing industry these days. But if officially you're an intellectual property lawyer with Alter, Kendrick, and Barron. But you are on the board of ASCAP, you have worked with SHOT, with European American Music, with Boosey and Hawkes, Universal Edition, you're on the board of the Copland Fund, the Thompson Foundation, just about anything that's happening in American music publishing these days. It seems like Jim Kendrick is involved. So it's a thrill to have you here at the University of Michigan.
Thank you. It's great to be here.
So we're here today to talk about copyright and what sort of intellectual property might mean for young musicians today. So what exactly is copyright? I mean, is it just the right to make copies, or?
No, it's a bit more than that, although that's where it started. Copyright is actually the legal device by which creators are given certain rights that they can use to protect and control and make some money, hopefully, off their works. And it's a federal law, comes right out of the Constitution, and it has been around, started in the UK in the 16th century, came right over with the British legal system that we adopted and brought
from the Statute of Anne, like way back
exactly,
in whatever, 15-something.
1554.
That's great. So copyright is actually a bunch of different rights, right? Or at least they're similar. In intellectual property, there's a bundle. Can you sort of tell us what are the different components of that?
Yeah, there are 6 exclusive rights, and exclusive you should take with a certain grain of salt because there are lots of exceptions and restrictions and compulsory licenses and things. But the 6 exclusive rights are the right to make copies, which is the basic copyright, the right to make derivative works. Derivative works are works that are based on a copyrighted work.
Like a musical arrangement, for example. You take somebody's melody, you recast it in the orchestration, that's a derivative work.
Right. Interestingly enough, a sound recording is a derivative work of the musical composition. And the rights situation in sound recordings flows from that relationship. Then there's the right to distribute copies. You have a right to make copies, there's a separate right to distribute copies. Think of it this way. If someone is giving the right to a printer to make copies of their work, that printer is going to deliver it to a distributor, and they're the ones who are going to make the copies available all over the country, all over the world, possibly. So that's a separate right. The 4th right of the copyright owner is the right to public performance. They can control public performances, and there are different ways. ASCAP and its similar organizations, BMI and CSAC, work in that area. There's also certain rights that are licensed directly by the copyright owner or the publisher. The 5th right is the display right, which in the music field we didn't think meant all that much when the law first came in 1978. And then nowadays, of course, if you have graphic notation on a computer screen, that's a display. So that's become important as well. And then the 6th right, which was added in the mid-1990s when the possibility of digital transmission of music started to become feasible, is the right of a sound recording owner to control public performances by digital means only. We have a somewhat anomalous situation in this country where if a radio station plays a record over the air, they have to pay for the composition. They would do that to ASCAP or BMI in most cases, but they don't have to pay the label or the artists because that was considered to be promotional use.
I see.
In the digital world, that's not the case.
It's different.
Money is being paid.
So an internet radio station is different than a terrestrial radio station.
Yeah, it is, and even a terrestrial radio station that's simulcasting is under that 6th right of the copyright owner. So
this performance right, does that mean if I buy a piece of sheet music from, say, European American Music, that I may not always have the right to perform it, or what does that mean exactly?
That's absolutely correct. Normally, the sale of a copy does not convey the automatic right to perform the work. The performance of the work in a public setting, you can do it all you want at home or in a private teaching or whatever, but a public performance is a separate right, and that is usually, as I said, in the case of non-dramatic performances, licensed normally through a blanket license that this university or many concert halls and other performing venues would have with the performing rights societies, which gives them the right to perform anything in the repertoire as much as they want for whatever the period of the license is.
So that's what we do here at the University of Michigan. So we have big concert halls, Hill Auditorium, Merced Hall. We pay into these licensing groups like ASCAP.
That's right.
Right, and then these performances are tracked, and then that sort of money is put in a pot that's divided among all the creators. Is that sort of how it works?
That's in essence exactly what happens.
That's great. So if I'm say I'm an aspiring composer or musician, like why would I need to know all this stuff? It seems like legal mumbo jumbo. Do I need to know what this what copyright is.
If you want to make a living as a composer, it's quite useful to know.
Quite useful, yeah.
Because the tools that it gives you are tools that you can use to, first of all, control the use of your work. In many cases, if someone wants to do something with your work to which you object, that you have the right to stop that.
Right.
But if someone wants to use your work, use your intellectual property, whether it's in a performance or whether it's in a film soundtrack or a sound recording, you have the right, A, to agree to that in most cases, and B, to be compensated, sometimes at a negotiated rate, sometimes at a fixed rate, depends on what the use is.
Okay. And if I'm a composer, I want to keep my copyrights, right, and control that. Are there different kinds of publishing, or is it different between like lyrics, or how does that work?
Well, what normally happens is that the music and the lyrics, say of a popular song, would be licensed at a single entity. And as I said, for non-dramatic performances, in other words, performances where there's no costume, scenery, or set, so to distinguish that between a musical comedy or an opera or something like that.
Right, so that's grand rights, right? Grand
rights, yes. Most of these non-dramatic performances, which are called small rights, are licensed through these societies, which aggregate copyrights from, in the case of ASCAP, 500,000 members. And you can imagine the number of copyrights, when you multiply that by the number of members and their output. These are licensed to the performing organizations or to the venues, and as you say, a record of the performances is made, sent to ASCAP, and the money goes into the pot where it's divided up. This can be a very substantial form of income for composers, and many young composers still in university sign up with one of these organizations.
So is there a time that's too early, or do you sign up for letters CSAC, there's BMI, there's ASCAP? What's a young composer to do these days?
Well, ASCAP and BMI both have concert music divisions where they have specialists who work with young composers in many ways, not just on the nuts and bolts of getting paid, but also there are competitions, there are awards, there are things that then they can give some career guidance and all. And I don't, although I'm on the ASCAP board, I don't have a preference as between ASCAP or BMI that I would automatically say you have to go to ASCAP. My advice to a young composer is get to know them both and see which ones you feel that you would like to work with. Basically, they accept all comers.
Do you have to be invited, or do you just go on a website and fill out a form? And
go on a website, fill out a form, and you're in.
That sounds like a good idea.
Yeah, and the time to do it is when you are starting to be performed in public. It is never too early. If you're getting we have an ASCAP member who joined when she was 9 years old, and she has pieces performed in a symphony concert. Money will flow back from that.
Now, if I'm a member of ASCAP as a young composer, does that mean somebody else is controlling my copyright, or is it still my copyright?
No, it's your copyright. The only thing that ASCAP takes care of by law, actually, is the public performance right. They don't get involved in print. They don't get involved in licensing recordings for to be made or for film soundtracks or anything like that.
So if I want sort of my fair share of that public performance pot, that all these licenses are being paid, then I need to register for ASCAP.
Yes, you should. And it's a very, it's easily done online. You don't have to take a test. You don't have to pass an audition. If you've got music that somebody's playing, that's good enough.
Great. So say I'm a young performer and I want to make a recording. I've just heard a great new work by, say, Michael Dougherty or Bright Shang or some of our composers here, and I want to make the recording. What kind of rights do I need to be concerned about?
Well, that's called somewhat archaically the mechanical right. It's the right to reproduce a musical composition on a sound-only carrier.
As if there was a needle on a disc and it was doing something mechanical.
Or it actually comes out of the piano roll and music box world.
Oh, wow.
So that's the term that was adopted in the early part of the 20th century, and it's stuck ever since, even though there's nothing mechanical about
so I need mechanical
discs or streaming or anything like that.
So do I fill out a website form, or how do I get a mechanical right?
There's an organization, it's non-exclusive, but a lot of publishers work through it, called the Harry Fox Agency. And the function of the Harry Fox Agency is to represent music publishers for the purpose of issuing mechanical licenses. There's something you need to know about mechanical licenses, which is that once a work has been recorded and released for commercial, sound recordings with the permission of the copyright owner, anybody else can come in and make a recording of that same work, as long as they file what's called a notice of use, or they make application to the Harry Fox Agency and pay a relatively small amount of money per disc.
It's like 10 cents a copy, something like that?
Well, for a song, a pop song, it's 9.1 cents per copy. If the duration's up to 5 minutes, anything that's more than 5 minutes, it's 1.75 cents per minute.
I see.
Per copy.
So if I'm doing the world premiere of a new say flute solo that Bright Cheng has written for me. I'm certainly working with Bright, but what's the difference there? I don't have a compulsory license, so how do I get permission in that case?
Well, Bright, I believe, has a publishing arrangement with a commercial publisher, G. Schirmer, and so you would go to them, and they would handle those negotiations. That's what a commercial publisher does get involved with, unlike ASCAP or BMI. That's one of the areas where they will represent the composer for the purpose of issuing first recording licenses and things like that.
But it's a little bit different.
Yeah.
Great. So one of the things I'm wondering about is, I think a lot of music these days, there's sort of a sense on the internet that everything should be free and nobody should have to pay for anything. I think a young musician or a composer might be compelled to think, well, I just want to get my name out there, so I'm just going to sort of throw myself onto the YouTube and whatever. So what are some of the pitfalls or the dangers that a young musician might have and maybe giving away more than they think they're giving away? So if you have any horror stories or any advice for that kind of person?
No, I got plenty of horror stories. It's been going on, though, forever. It didn't start with the YouTube era. What I always suggest to young composers is that if they're serious about making this their livelihood, they have to think like a business person, a very small business person, and say, okay, there are certain things that you do to get yourself established that you might not do when you're more established. You might allow free performances in order to get publicity. It's like having an introductory offer if you open a shoe store or something like that. But you don't want to do that forever, because after a while people will just get used to the idea that you don't think your music is worth anything, and therefore they can just use it with impunity. You have to be strategic and always try and get something for it. If you have a friend who's a choreographer, and he says, okay, let me use your music, I can't afford to pay anything, but this will get it out. You might say, okay, that's great, we're friends and all that. But if you license that choreography to somebody else, they got to come to me so I can charge them, because if you're going to get compensation for that, so should I. Or I'll let you do it this season. If you do it again in future years, then you'll pay me X. Approach it a little bit businesslike. It's not all just I mean, that's part of, I guess, one of my roles in this ecosystem is to remind people that they do have to get paid for these things at some point, or else they have to go do something else.
So one of the things, I mean, I've certainly noticed this as a historian, it's that historically composers who keep their copyrights end up doing better in the end. Of course, the composers we're studying in history are the ones who become famous, right? But if they're going to actually make a living at it, they'd have to retain their copyrights, not give them away. But so are there ways? There's sort of ways to give them away for a short period of time, or in sort of non-exclusive kinds of ways.
There are a couple of business models, but it's interesting you mentioned composers that hold on to their copyrights. The most famous person who still considers this to be his absolute advice to young composers, I think, is Philip Glass. Okay, but Philip Glass has made arrangements with commercial publishers to handle lots of aspects.
He has his own company.
And he has his own company where he publishes other composers.
Interesting.
I worked with a number of composers who kept their copyrights up to a certain point, and then when commercial publishers were interested in them, they sold the copyrights for a very substantial capital sum while still retaining their writers' royalties. See, this is something that I think we ought to clear up. When you sell your copyrights in the classical music environment, and most music publishing environments, you're not taking a lump sum and never seeing another penny. Normally what's happening is we think of the income from copyrights in the music area as having a writer's share and a publisher's share. That's the way ASCAP and BMI are set up. You can sell the copyright and the right to receive the publisher's share and still retain the writer's share. If the publisher then is able to increase the income that they make, which of course they're incentivized to do, you get your share of that as well, and generally the share is at least 50%, if not more.
So that's why you might want to sign with a commercial publisher. They're going to amplify your career, get you more performances, more exposure. Orchestras are going to look at a Boozy or a Theodore Presser as a respected source for quality materials. They're going to know it's gone through a certain selection process. Yeah,
we like to think that's true, and I think it really is true. One of the things that has developed is that most of the commercial classical publishers, very few of which are owned or associated with the big pop publishers, they're just not natural links, with the one exception of my client, Universal Music Publishing, which has the Durand Salabert recording catalogs in Europe, and do run that separately in the way that Boozy runs it, and Music Sales run their businesses. there's a limited number of slots for composers in those places because what they want are long-term, mutually supportive relationships. A composer who comes in and drops their scores on the desk of the publisher and takes a check and says, okay, you take care of them, will probably never see a check again. It is absolutely a cooperative relationship. The composers who are able to go out and be involved with their music, work with the publisher to extend their reach, go places they can't go, do things that they either don't want to or can't do themselves in terms of promotion on the internet and in various other ways, they're the ones who are going to do the best commercially. And, you know, as I said, relationships go on for decades.
So even when you sign this big deal, you're still, as a young composer, you're still an entrepreneur. I mean, you're still having to be out there giving pre-concert talks. And
well, the other thing you have to remember is that the primary source of income, even for really well-established living composers, is not the royalties.
Yeah.
It's the commissions for the next works.
I see.
You know, an opera commission for a top-level composer can run into the hundreds of thousands of dollars. A good orchestra commission will run, you know, $40,000, $50,000, $60,000. Right. And the amount of royalties that you get from repeat performances and rental fees of the works after that are supplemental to what you're making, you know, for writing news in most cases.
So if I'm a young composer and I get this invitation to have this conversation with a major publisher, I should probably answer that phone call or answer that email and just at least explore it.
It goes, yeah, absolutely. You know, we every now and then I have clients on both sides of the fence, a composer who wants to make a deal with a publisher or vice versa. And I always encourage, you know, it doesn't matter which side I'm on, I always encourage both sides to think really carefully about whether this deal will enable the music to get places it couldn't go otherwise. I mean, these days there are other options. There are composers who work with companies like Subito Music and Bill Holub to simply handle the logistics of making their materials, you know, presentable and getting them out for, you know, for performances. And they do some other services as well. But it's not a full publishing relationship. There's no copyright transfer. Just a little side note on copyright transfer. Copyrights outlive their composers. Right. Which is a nice change in the American law. We had a situation where Irving Berlin outlived a lot of his most famous copyrights because they only lasted for a fixed term of years. Copyrighting new works runs for the life of the composer plus 70 years. So you do, at a certain point in your life, have to think about who's going to look after this stuff. I may be able to do all this myself, but who's going to look after this? And this is a conversation I have very often with composer clients.
So a lot of our students are connecting with student composers and they're commissioning works. What are the kind of, you know, I think when students are creating their own business venture or something like that, it seems like it'd be a good idea to have a conversation about exactly who's doing what and who owns what and writing things down. What are the kind of pitfalls that you see in these early entrepreneurial efforts, I guess?
Well, it isn't even in the early ones always. There is a certain incredulity sometimes when you say to a commissioner who's about to, you know, commit $40,000, $50,000 to a new work, to say, okay, you get you know, exclusivity for a year or two and make the first recording or whatever, and then that's it. Then that belongs to the composer. If the composer has a publisher, they're going to go out and they're going to make money on that. You know, if they can, by getting additional performances. And sometimes, you know, people who are new to the commissioning game just sort of say, well, how's that? I mean, I'm paying a lot of money. I should own this piece.
Right.
And that,
so the copyright stays with the composer.
That's right.
The intellectual property, the creativity is theirs, unless you negotiate something else.
Well, that's right. And this is something that is a big pitfall in commission agreements. If you're not careful, one of the worst things you could do is sign a commission agreement which uses the term work made for hire.
Right.
Except in the television and movie field where that is the business model. Composers should own their own works. Doesn't matter who commissioned it and for what purpose. You might give them a panoply of rights, you might give them free performances for years and years, but you should be able to retain the rights to the composition and be able to exploit that composition down the road.
So if you're a young composer and someone's asking, you've got to look for that word,
magic
work made for hire,
hire,
and be very careful if that's what's the relation. Just know what you're getting into.
That's right.
So that would mean work made for hire would mean you're transferring the copyright. You're
not
doing
even
as an
transferring
employee.
the copyright.
You never own the copyright.
You never own the copyright.
I see.
Yes.
Interesting.
That's what movie companies want to have because they consider it, you know, a component of everything that they bring, the screenplay, the acting, the cinematography, all that kind of stuff. They're allowed to keep all that from the beginning, but not in any other context.
Well, one of the things I love working with you, Jim, is that you're a musician yourself. You actually were a professional oboist. You played in the Brooklyn Philharmonic, and so you see the business from both sides. If there are some of our students who might be considering a career in law, what do you think? Is there exciting things happening in intellectual property law these days? Is that a viable career? Or?
Well, it's funny you say that, because I went to law school in 1979, and when I came out of law school, I was very much figuring I was going to have to do straight-ahead corporate law and all this kind of stuff. And through a lot of good luck, I was able to be introduced to a partner in the firm that represented Leonard Bernstein. And through that, we started a relationship which continued until about an hour ago. Hopefully will continue even longer than that. But it was a backwater, intellectual property. What's that? People with funny glasses and all this kind of stuff. And of course, once the the digital revolution came in from the late '90s forward, all of a sudden it was front page news or the cover of Newsweek, and all this kind of stuff. And there's tremendous upheaval right now in that whole world still. ASCAP and BMI are going through a review of their consent decrees, mainly to do with the relationship with the streaming companies, the Pandoras and the Spotifys, and everything is converging, and you can get everything from everywhere all the time on everything, including this little thing in my pocket.
Right.
It is a very exciting field, but I have to say I'm extremely lucky, because I've been able also to work through the work with the Copland Fund and some of these other foundations, right in with the music, and I'm able to come and deal with young composers and performers and all that. And there aren't a lot of people doing it, so there's got to be room for at least one more out there.
That's great. Well, thank you so much for joining us today. It's great to have you at the University of Michigan.
My pleasure. Thank you very much, Mark.